So we ended off just before we had this discussion with the question, if someone else has a document who's not a party to the suit, can you seek discovery from them? The answer was yes, and I agree the answer is yes. Then it was suggested that you do that by means of an application to court. And I said, well, there's an easier way. It's called a subpoena. And what you do is you would subpoena, for instance, a bank manager, and you'd ask him or her to bring along the bank statements of a particular person or company. You could subpoena a superintendent at a hospital, and you can ask him or her to bring along certain hospital records relating to a patient. You can subpoena a doctor and ask him or her to bring along patient documents. They're not privileged. Same with psychiatrists, etc., etc. So when a third party is under control or in possession of documents relevant to the suit, you can issue a subpoena for that witness to come to court, or that person to come to court and to bring along on a specific date all these documents. And that's how you secure discovery by a third party. A subpoena is a document issued out of court. It calls upon a party to appear and present themselves at court. And in this case, a specific type of subpoena where you ask for documents to be brought along. And if that person does not appear, then I, as a practitioner, would seek a warrant for his or writ for arrest. Because they should have been there. So that's what a subpoena is for. You subpoena someone, and if they don't appear, that principle is tried even in the magistrate's court. So no, the person on whom a subpoena is served doesn't have an option. Of course, if it's impossible for that person to appear, then that needs to be considered by the court. And if it's a situation where these documents are no longer in existence, or they are not in the person's possession or under his or her control, then he or she should come to court and say that to the court, and the court will then listen and consider. If the documents are given prior to that date to both parties, and both parties agree that it's no longer necessary for this person to be at court, then they can release him they can ask the court to release him under the subpoena. Most certainly, it's happened. So it can happen, but that'll be both, because if a party has been subpoenaed, it's not just one party who's entitled to release him. It should be obviously with the leave of the court, and the other party should have an opportunity to make representations regarding the releasing of that witness under a subpoena. So it won't just simply be, oh, thank you for the documents, there you go. It will be a situation where it's agreed between the parties, or the court then orders it. Either way, the court will have to order it. Absolutely. And what has happened previously is that what's happened in practice, and it's probably a good approach to proper preparation for trial and to avoid delays at trial, is for parties to sort out their subpoenas beforehand and to actually have this person appear either at a status hearing or at a case management conference or at a pre-trial conference, so that this person comes along with the documents then, so that they are given to the parties well in advance, because not all subpoenaed witnesses are actually witnesses who cooperate with the parties. They may cooperate with the court, but not necessarily with the parties. So it may be that you subpoena this bank manager. He's quite upset with the fact that he's been subpoenaed. He's not going to be nice and just bring the documents in advance. So if he's ordered to be in court, say for instance during a pre-trial conference, then he hands over the documents then. The parties make their copies, and then he can again be subpoenaed to appear at the trial if further questions need to be asked on these documents, or if he needs to be questioned relating to the documents, or his refusal to bring documents or whatever. That can always be done in advance of the trial, if it's just about the documents. It has been done previously, it can be done, but for various reasons you may only want, especially if it's a witness whose evidence is pivotal to the trial. So your purpose is not only to seek discovery, but it's also that his or her, like for instance a bank manager, all you want from him is, for instance, the account statements. So once you have the account statements, you're not going to question, he doesn't know whose account, well, he knows whose account it is, but I mean, he's not going to know what transactions these were for. He can only he can only certify that this is the correct account and account statements. So in that instance, possibly it would serve a purpose to get the documents in advance. If, for instance, it's a witness whose evidence, who has personal knowledge and documents. So, for instance, in a recent case that I had, I appeared for one property developer and a colleague appeared for another property developer, and it related to a property that was first sold to the one party by the City of Windhoek, and then the sale was cancelled by the City of Windhoek, and then it was allocated to another party. So the one party sued the City of Windhoek for specific performance, and obviously the other party was joined because it had now in the meantime been awarded the property. So the City of Windhoek said, I'm abiding. This is what I've done. I'm abiding by the decision of the court. I'm not opposing, but the two property developers are now fighting with each other as to whether this cancellation was valid and who must now get the property. So obviously the City of Windhoek's official, they're not a party to the proceedings. They're not going to come and testify. So you would want to call him or her, subpoena them to bring their documents and testify, because their testimony will be very important. So in that instance, it makes no sense to get it in advance, because you're going to have to call him or her in any event. So it will lead to delays. But you can be pragmatic, and you can be, there are certain ways in which you can try and alleviate the need to delay if it's only for purposes of discovery of documents from a third party. We've dealt with what a discovery affidavit looks like. I've spoken to you about Rule 28, Subrule 8, where you seek specific perform a specific discovery from another party. Now, please bear in mind that you need to be specific in what it is that you want him or her to discover. So to say all documents that were ever in existence relating to this issue is too wide, you won't get that. There's no way that party can answer to that. Once a notice is served on a party to deliver this specific discovery of documents, there's a specific way in which a party needs to answer to that notice. And you'll find that in Subrule 8. And we're looking specifically at Subrule 8b, Roman 2. A party must deliver, Roman 1, deliver the documents, analogues, or digital recordings to the party requesting them within a specific period of time, or state on oath or by affirmation within 10 days of the order that such documents, analogues, or digital recordings are not in his or her possession, in which case he or she must state their whereabouts if known to him or her. So it would be, I don't have this in my possession. The last time I saw it was in Mr. X's office. Or I've never seen such a document in my life. I don't know whether it's in existence. Or I had it, but it's since been destroyed in a fire. Okay. So this is what is expected of a party when answering a request for specific discovery. That more or less takes care, in broad terms, of the discovery process. I've dealt with a supplementary discovery. You'll find at page 95 of the bundle, the bundle of pleadings that you were given. You'll see there's a additional or supplementary discovery. Now, again, it's sort of a run-of-the-mill type of document that's drawn up, and I'm just giving further documents now. One would have thought that an explanation is necessary, given the fact that in the previous statement you say, I'm not aware of any other documents in existence that are relevant. So why the supplementary discovery affidavit? It could be that you've come across new documents, that you made a mistake, that you accidentally omitted something, that new issues arose between the parties, which now gave rise to the new further documents being discovered. But one would expect in a supplementary affidavit that a party at least sets out what exactly gave rise to them to the need for filing a further supplementary affidavit, discovery affidavit. The next question that arises with supplementary discovery is simply, What is it necessary to obtain leave from the court? Strictly speaking, yes, because discovery has been arranged and agreed upon, and the parties have complied with that. Now you want to revisit that and introduce further documents, you would probably need leave from the court. Some judges are more relaxed and allow parties to arrange this amongst themselves and then sanction or order such a filing of further discovery, and where the parties are not really an issue, that's fine. Other judges are very strict and tend to say, you've missed the bus, you would have to apply for leave to file a further supplementary affidavit. What the reason for that, the reason why parties can't just file supplementary discovery affidavits as they please, is to avoid a situation where the rules try and force parties through the case management process to get the proverbial ducks in a row. They cannot sit back and relax, and then shortly before trial they want to run around. And in the old dispensation, various matters were postponed due to discovery not being done, due to these pre-trial procedures, expert witnesses not being filed summaries for, or statements or whatever, notices. These pre-trial procedures often caused the delay and a postponement of matters on the roll. Now you can imagine, court roll time is precious. We only have so much of it. It's not infinite. And now, more often than not, you have 4 matters on the floating roll and not one of them is proceeding. So other matters that's now further down the line could have actually proceeded and could have been finalized, which is why the rationale behind getting parties to get their ducks in a row while advance of the trial. So you shouldn't be allowed to simply at a whim file further discovery and whatever supplementary discovery because it is abused. What do people do when there's a system? They try and get around it. What do people do when there are rules? They try and make life as easy as possible within those set of rules. So what do? Attorney says, oh my word, we need to file a discovery affidavit next week. I haven't even gone to, just make a list and we'll file it. And then we'll deal with supplementary discovery. And then comes preparation for trial, and 5 days before the trial, there's a supplementary discovery affidavit with like 57 documents. You see. So that's why it's really a process which should be well managed by a judge to make sure that the parties properly prepare. Circumstances arise. You can't be too stringent. Sometimes parties make an honest mistake and omit to actually add a document which they should have. That's easily explainable, and you wouldn't expect that if you've made an honest mistake that you've just forgotten to add 3 files. You see. So I'll be with you in a second. Same principle applies to documents which come to your knowledge afterwards, or issues that have changed through amendments that require further discovery. These things happen, and you need to be mindful of that. But within having said that, please be mindful of the fact that if parties can abuse this process, they will. They will, and other litigants need to be protected against a situation where you do a flimsy first off discovery affidavit, and then comes this magnitude of a supplementary discovery. That's exactly what I referred to that earlier before the break, and I said it's a very wide and sort of difficult thing to say, because you're saying under oath that you have nothing else, you never had anything else. So that's why I'm saying in a supplementary affidavit, discovery affidavit, one would expect at the very least that a litigant explains why, despite what is stated there in the original discovery affidavit, I now want new documents to be discovered. You see what I'm saying? And it's been cross-examination material for years, and practitioners just continue to disregard the importance of making an allegation as in paragraph 5, which means that you should have been diligent as a practitioner or as a litigant, and you should have gotten all the documents ready. And now that paragraph, more often than not, leads to a finger pointing. Yes, but my lawyer did this. Then the lawyer said, no, but you did this. And then that's what happens. It's just because it's poor preparation. It'll probably be one of the bases that you use in opposing further discovery. But whether you're entitled to use that to stop any further discovery ever, it's probably not going to take you very far, because the court will take into consideration the circumstances. If it was malicious and the document to be discovered is to your detriment and it's close to the trial, etc., then the court may actually just refuse the party to proceed. But then again, we get to postponements and cost orders and condonation. We'll get to that tomorrow. And so it's a difficult question, but no, I don't think that a party can simply rely on that as conclusive that the other party will never again be allowed to discover. Will definitely go to his or her credibility, won't it? Not some, most. In fact, you'll probably be shocked to know in practice that those documents are more often than not drawn by a secretary. More often than not, the lawyer doesn't even see that document before it's signed by the parties, or by a very junior practitioner. And that's why I said right at the beginning, it's probably the most important process or part of pre-trial procedures. But its importance is so often overlooked by practitioners. And it's left to people to do who, like I said, secretary, paralegal, someone who, and that's how, so you're quite correct. That's why the supplementary affidavit and the affidavit in this file looks exactly the same. It's copy and paste. So that's why I said people should be wary of what they let their clients sign, and clients should be wary of what it is that they're signing. And discovery should actually get more attention from practitioners than it possibly has. And often, if you do proper discovery, it often leads to a settlement. That's how I experience it. All right, so that is discovery, supplementary discovery, discovered documents. Please, again, bear in mind that having made discovery does not mean that the documents are now before court. They still need to be handed up as exhibits unless they are attached to pleadings. You'll find reference to that in Rule 28. And that then deals with discovery. Okay. Expert testimony, plans, photographs, inspections, medical examinations. So you'll have to have a look at Rule 29, 30, 31, 33, and 36 for purposes of this. I won't spend too much time on this. Please bear in mind an expert is there to assist the court. So an expert doesn't make the decision on behalf of the court. An expert can, for instance, say, where, let's say, medical negligence, you'll have a doctor or a professor in medicine who comes and testifies and says, well, in my view, the doctor, who's the defendant in the matter, didn't properly attend to the patient, should have done it. The expert doesn't make the finding of negligence. That finding is made by the court. So the expert never makes the decision on the court's behalf. Now my question is, can you call a legal expert to testify in court? Yes. Can you make use of a legal expert? I'm not a legal expert apparently yet, but I'm aspiring. Can you make use of a lawyer or a senior advocate or a professor in law, any legal expert? Who says yes? Let me ask you, in any possible fathomable situation, are you ever entitled to call a legal expert to give evidence on legal matters in a court of law, in a high court? You wanted to say? On legal issue. Well, I mean, I am also an expert on my husband's state of mind, but I'm not going to say legal expert will testify only on legal issues. Okay, to testify on legal issues. Please don't say that to persons, because that'll be contravening rules. I'm not allowed to specialize. We're not allowed to say I'm specialized in this or that or the other. It may be that my practice involves more civil. I rarely do any criminal work. I don't have much exposure in the criminal circuit. I don't do criminal work. That's just how my practice has evolved. So yes, if someone comes to me with a murder charge, I'll say to them, maybe I'm not best equipped to actually deal with this murder charge. Maybe go to my colleague down the hall who does this more often than me, but I'm not allowed to specialize. What we called, it's really called forensic experts, in the sense that we spend more time litigating. And the idea behind a referral, I'm not here to advocate referral or non-referral bars, I just like my work and I like to do it. But the idea behind it is that when you're a legal practitioner and instructing counsel, your practice is of such a nature that you often don't have the time to prepare for proper litigation, in the sense that you have 1,000 files, whereas I may only have 100 files at a time. So I have the time to spend a week in court and focus only on that matter. So it really is a matter of logistics. Then, of course, my fees per hour is, even though I'm 14 years in practice and there's a junior lawyer who's now 5 years, her fees might be more than mine, simply because her practice is more expensive than mine is, because I need a secretary and a telephone and a computer to operate. So there's different nuances, but to answer your question, I don't specialize in a field of law. I am a qualified lawyer, so I need to be able to do all kinds of law. But it's also my ethical duty to tell a client when something is not within my abilities. So yes, I don't have much exposure to criminal law. I should be able to do it because I'm an admitted practitioner. So I should be able to get up in a criminal court and help myself. But I will say to a client, well, I urge you to consider perhaps appointing my colleague who does more criminal work than me, and she or he is better equipped to assist you. But I'm not allowed to say, no, sorry, I specialize in this, and I'm not even allowed to actually not accept a brief if I am available, unless I have an ethical issue why I can't accept the brief. So you say yes, you think so, because people specialize in different areas of the law. So maybe a judge needs assistance in certain areas of the law. That's one qualification. You wanted to...
But what I would say is that...
As a legal expert, or was he a factual witness? I've also testified in court. I actually testified in an attempted murder trial not so long ago.
Well, then it boils down to...
I was the lawyer, sorry, so privilege was waived, so I had to testify. Well, I think in most cases where my clients have an interest, I want to assist the court by telling the judge what he or she should find, but that doesn't mean that it's allowed. Okay, so essentially the answer is no. You don't call legal experts to assist judges. Judges, if they are not competent to make a finding, they shouldn't be a judge in the first place. That is the answer. There are exceptions. The exception is this. When you want to prove foreign law, you need to call a foreign legal expert to come and tell this court what the law is like in Germany, what the law is like in France. It may be that foreign law is applicable. Remember, if you don't prove foreign law, what is the presumption? It's the same as our law. Okay? So you need to, if you want to rely on foreign law that's different from our law, you need to prove that. And to prove that, you call a foreign legal expert. But you will not call a legal expert to tell a judge what the law he or she is applying is. Never. Well, I mean, you can try it and then see what the judge says. Let me know what the judge says. But no. So an expert is someone who assists the court. It's someone who knows a field other than law, which the judge is not an expert in, because the judge is an expert in law. And then that expert must be duly qualified. And by qualified, I mean actual qualifications and or experience. So in certain fields, such as, let's say, cattle farming, you won't necessarily have a qualification. You may have an agricultural qualification, but cattle farming and the nuances of cattle farming or meat production, export of meat, those things are things that you really, you become an expert on when you spend time in the industry. So a cattle farmer who's has been farming cattle for meat production for the past 20 years on a large scale would be someone who could tell you something about the procedures for exporting of meat, who can tell you about the objectively speaking, can tell you about meat prices, can tell you about meat quality, can tell you about when cattle are weighed before they are slaughtered, and what's the dry weight and the wet weight and the only reason I know these things is because our job is interesting. You get to deal with all these people all the time, and you get to know about various areas outside the law. But what I'm trying to say is it depends on the field. So you won't get someone who has been walking around in hospitals for the past 10 years telling you about medical negligence. He or she needs a qualification. And if you want to talk about medical negligence of a surgeon, you don't get a gynecologist to come and testify, you get a specialist surgeon, preferably someone who's lecturing at a university of some sort and is able to come and assist the court in making a finding, doesn't make the finding on the court's behalf. So you'll have to file a notice, and you'd have to say, this is the expert I'm calling, this is what his name is, this is what he or she is, these are his or her qualifications and experience, and this is what they are going to come and testify on. And then you get the expert summary, which is the expert witness statement, which says usually what parties do. I think it depends on the judge that you're appearing before. You file your summary, which is a witness statement for an expert, and you attach the report either way. You can either duplicate the whole report in the statement, or you can, for purposes of brevity, say, highlight those portions that you want to rely on, say the report is attached, I refer to it by reference, I will be referring to it, and from the report the following are this is what I've done and these are my conclusions. The expert will have to say what he's done, what his mandate was, how he's done what he's done, and what the conclusions are and why he arrives at those conclusions. Okay. Otherwise, it's of no assistance to the court. So the whole idea of experts is to be of assistance to the court. The question you need to ask yourself, is this something that requires expert evidence or not? In other words, if my client says his car was damaged to the tune of 50,000 Namibian dollars, how do I know? Just because my client tells me, or because my client went to an assessor who looked at the car and said, you know what, this car is damaged and you need to replace this, and as a result, this is what these cost, so this is what the damage to the car is. Or a panel beater who does this all the time and knows what parts are worth and what it costs to fix a car. You'll get some of these panel beaters, they've been operating for 30 plus years. You can wake them up in the middle of the night and they'll be able to tell you what the damage to a car is worth, and et cetera, et cetera. So there you'll need an expert. If your client says, I sold 30 head of cattle to the defendant and we agreed that we will use the prevailing meat price on that day or that month, is that something for which expert evidence is required? Probably not. It's an objective, determinable fact. So the situation will dictate whether experts are necessary. They're very important in a trial. Please remember, they never make the decision. They can reach a conclusion and say, based on my experience, this is what I think, but it remains opinion evidence. Opinion evidence can only be used when it's relevant and of assistance to the court. Okay. Plans, photographs, inspections, Rule 36. I'm not going to be spending a lot of time on that. Just know that if you want to make use of plans, photographs, or you want to do inspections, you use with a mechanism in Rule 36. You can read it. It's straightforward. Same with medical examinations. That's Rule 33. Please have a look at that. That is where one party would want to subject the other party to a medical examination. For instance, where your claim is for damages for loss of a limb and loss of amenities of life, you would want that party to undergo a medical examination by your own expert in order to prepare your own report. I've often heard in court practitioners saying, well, we didn't file an expert report yet because we didn't know whether the other side will be filing an expert report. Now, that may hold true for a defendant who doesn't bear the onus. But the thing is, a party who bears the onus cannot wait to see what the other side does. He or she must make whatever arrangements need to be made in order to prove their case, which would include lining up the necessary experts. Okay, then we move on to request for trial particulars. That's Rule 26. Strictly speaking, with the new rules, the whole idea of further particulars fell away. So you can't, during pleading stage, as I told you yesterday, you can't seek trial particulars. But what has happened is that in terms of the pretrial procedures, and in particular, if we just go to Rule 26, you will see Rule 26 deals with the pretrial conference. So at the pretrial conference, the court accepts that discovery has taken place, witness statements have been filed, and all of that has been done. And as a result, this matter is now ripe for trial, and therefore the parties are given one, having considered all of that, the pleadings, the discovery, the witness statements, there may be some questions that arise from that may be answered in advance of the trial and may alleviate the need to, or may clarify certain issues, or alleviate the need to actually decide that issue, and therefore the court will allow the parties one last chance. And there's the only reference in the rules is sub-rule 6L, which says particulars required and necessary. Those are the important considerations, and that is what will guide whether the court will force a party to provide such particulars. Required and necessary for trial. And the party giving trial particulars must identify by name, job title, address, and telephone number of all factual witnesses who assisted in the preparation of the particulars, and further identify and describe all documents that the receiving party has relied on to assist him or her in preparing the particulars. So it's not really the old trial particulars. What do you say about that? What do you say about that? What do you say about, do you admit this? Do you admit that? That's not what this is about. It's where, for instance, in preparation for trial, look, I mean, it's used in practice, I've seen, by practitioners to become a sort of the old request for further particulars, but that's not the purpose. The purpose is to clarify issues that have arisen in the pretrial procedures and in order to prepare for trial. So it may be that you say that you made these payments on that day. To what account number did you make the preparation for trial? So it is different from the old request for further particulars, and then what may be requested and how should it be approached is along the lines of what I've just told you a moment ago. And it actually says so in the rule. Then we get to witness statements. I just want to finish witness statements and an indexing and pagination and practice directions before lunch, then we can proceed with the rest in the afternoon. All right, so Rule 92, and I think we should just page to Rule 92 as well as to the witness statement. Just see. You'll find an expert witness statement. Let's start on page 149. And we go all the way to once, so we just, you can, page 149 is the, is an example of a witness statement. Then on page 153, you'll find an example of an expert witness statement. Then on page 156, you'll find a expert notice, and on page 158, summary of expert evidence. Now you'll see this is, for instance, a panel beater. This is Mr. Erban Ulrich Klute. He says he's employed by Friedels as a panel beater and an assessor. I have more than 20 years in the assessing of damages to motor vehicles which were involved in collisions. To express an expert opinion on the costs of repair of such damages and the reasonable market and salvage value of vehicles prior to and after collisions. Okay, it's not the best drafted paragraph ever, but you can follow what they're trying to say. I confirm that during the 20-year period I had continuous experience in etc., etc., etc. And I confirm that from my experience I'm personally familiar with each of the following in an expert capacity. And then he says what he did and how he's come to the conclusion. So this guy hasn't got a physical qualification on paper. As far as I'm aware, there's no panel beater school that you go to get it. You go to a panel beater, you work for them, and you get the experience. So that would accompany your notice to present evidence. You say, be pleased to take notice that during the hearing of the above matter, the defendant intends calling Mr. Erban Ulrich Klute to give expert evidence. A summary of his evidence will be filed in due course, and then follows the summary, and then there's a witness statement. Okay. Now let's go to Rule 92, which deals with witness statements. After the case management conference or at the pre-trial conference, the managing judge must order the parties on Form 20 to serve on the other party a witness statement of the oral evidence of the parties serving the state, evidence which the party serving the statement intends to adduce during the trial in relation to any issues of fact to be decided at the trial. So in other words, if you want to call a witness, you need to file a witness statement. Now there's a bit of an anomaly or perhaps an inconsistency in the rules, and it's dealt with differently by different judges. Doesn't really matter. So I think you can address the court, and the court, as I said, the rules are there for the court is not there for the rules. So I think any judge would be open to hearing the unique circumstances of each of the litigating parties before it, and will make an order in the interest of justice. I hope to believe that that is the position all along and will remain the position. So essentially, it's whether you file witness statements here at close of pleadings before you go to pre-trial procedures. Or in other words, do you do like many judges do and deal with it in your case plan, which implies that it will be finished before case management conference. Do you do it here? If you're in Judge Geyer's court, you do it there. He wants discovery and witness statements sorted out in the case plan, and that's it. So we don't go to case management unless you've done your witness statements. Or do you, in terms of Rule 92, wait for the case management conference or the pre-trial conference? Neither would be wrong. You can do it there, you can do it there, depending on the circumstances. So if a matter, for instance, let me give you an example, and then you can tell me whether you agree with me. Divorce matter. The plaintiff is a husband, and he wants to divorce his wife. He attaches a settlement agreement to the particulars of claim, and the settlement agreement says he's basically getting everything, and she's getting 100,000 or 200,000. They've got quite a significant estate, a couple of million, so it's not she's getting very little. Children are out of the house. He says she's an alcoholic. She drinks a lot. She uses medication, antidepressant medication, and she uses foul and abusive, foul language, and she belittles him and whatever. And he says, I want to rely on the settlement agreement for our proprietary rights, and insofar as I can't enforce the settlement agreement, I want forfeiture, because we're married in community of property, so I want forfeiture of her benefits arising. She's a housewife. She's been a housewife all her life. He's got a few businesses. She then opposes the divorce, and she then files a plea, and she says, no, I'm not guilty of this conduct, and in fact, it's true that I left the common bedroom, but I did so because of the plaintiff's actions. This is what he did, and as a result, I want a divorce, and I want a division of the joint estate. Okay. Now the matter must go to ADR. So the parties prepare their respective briefs, their mediation briefs, and the matter goes to ADR. Do you think the likelihood of the matter settling there would be different? The parties have filed their witness statements, and the wife files witness statements not only for herself, but for her two major children, who say that their father has physically and emotionally abused a lot of them throughout their life in the house, that he's actually broken the son's nose at one point, kicked the daughter's ribs in. He has abused alcohol, he has belittled them, he's not been involved in their lives at all. He has intimidated their mother to the extent that they actually had to take her to a facility. She was fragile. She started drinking in order to cope with the fact that he beat her into a pulp daily, etc., etc. Do you think the plaintiff would be more likely? Oh, and then a psychologist files a statement saying this is the treatment that the wife undertook, etc., etc. Do you think a plaintiff would be more likely to settle after having received those witness statements? I would say yes, absolutely. No one is going to want to stand up in court. He's the only witness for himself, and he says, my wife did all of this, and then comes this whole bundle of witness statements saying, yes, mister, but look at what you've done to her throughout her life, and who are you to now seek forfeiture just because you are a bully? So it depends on the matter. In that instance, of course, deal with your discovery and your witness statements here already, so that you can send the matter to ADR with everything on the table, because parties are more likely to want to settle when their cards have been played, especially in matrimonial matters or matters where there's egos or emotion. That's just my personal experience. There's no written rule, but that might be the rationale behind sometimes dealing with witness statements and discovery right up front, which again we'll deal with ADR in a moment. But I always feel, although ADR is prescribed right at the beginning, I always feel that it makes sense to have all the cards on the table before the matter proceeds to ADR, unless it's impractical or too expensive to do so. All right. So what I'm actually saying to you is, in terms of the rules, you can either do witness statements here or you can do it here. You can't do it here. What must a witness statement contain? You'll have a look. The witness must indicate at the end of his or her statement that he or she believes that the facts stated in the statement are true to the best of his or her knowledge. Okay, let's have a look at the example that you've got, not the expert one, the one on page 149. There's a witness statement. So do you think this is a rule-compliant witness statement? To look at the details. So witness statements weren't required in terms of the previous rules, which means that if it's a witness statement filed in terms of the rules, it would be in terms of the new rules. Witness statement, the concept of witness statements was only introduced in the new rules in 2014. All right, so you said it's not commissioned.
No, I was under the impression that sorry.
Okay, no. Because witness statements are not commissioned. In fact, they're not even signed by the party making them. That's not a requirement. Some practitioners do that. They do file statements in the form of affidavits. I think it's a risky business, and I don't think that's what was intended, simply because you'll see also in the practice directions that the start of the trial, a judge needs to warn a witness that a witness statement has been prepared for him or her by a practitioner, that they have read it, they understand it, and that when they read it into the evidence, it becomes their evidence in chief, and therefore, if there is an inconsistency or an incorrect statement, they can be guilty of perjury. A judge must, before a witness testifies, must warn the witness accordingly. Okay. Then the court may give directions as to the order in which witness statements are to be served. So the court may say, in this instance, I want the plaintiff to serve their witness statements first, and then the defendant a week or two later. And then, of course, there's always the right of a party with leave from the court to amplify its witness statement, where, for instance, issues have arisen from the other party's witness statements subsequently filed. Or the court can say this is an instance where both parties must just file their witness statements at the same time on the same date. That will much depend on the judge and on the circumstances of the matter. Where the court is directed that a witness statement in a language other than English is to be filed with the court, the party wishing to rely on it must have it translated into English by a sworn translator and must file with the court both sworn translated statement and the witness statement that is in the other language. Sworn translator must do certain things, and a witness statement may only be used for the purpose of the proceedings in which it is served. So I can't go and fetch Mr. X's witness statement in another matter and then come and use it in this court, in my matter that's got nothing to do with the matter for which it was filed. If you want to rely on a witness statement, you must call the witness to give the evidence. A witness statement in itself is never. If you file a witness statement and you don't call the witness, the court may as well tear up the witness statement. It's not going to have regard to it at the end of the trial. Where a witness is called to give oral evidence under this rule, his or her witness statement will stand as his or her oral evidence in chief unless the court orders otherwise. You may amplify with leave of the court your witness statement and give evidence in relation to new matters which have arisen since the witness statement was served on the other parties, except that the court may give such leave only if it considers there is a good reason not to confine the evidence of the witness to the contents of his or her witness statement. So witness statements need to be thorough. Practitioners need to be diligent in drafting witness statements to make sure that they've covered everything that the witness would need to testify on. Before the witness reads his or her witness statement into the record, the presiding judge must admonish, I thought it was in the practice directions, it's actually in the rule itself, admonish the witness statement in the following terms: the oath that you have taken or the affirmation, etc., you understand, and you may be liable for perjury. It's your duty to tell the truth and to show if there's inaccuracies in your witness statement. Okay. Where a witness is called to give evidence at a trial, he or she may be cross-examined on his or her witness statement only and not on the statement of any other witness who has been called to testify for the party who called him or her to testify. Okay. So you cross-examined on your own statement, not on someone else's. And then in certain instances, witness statements may not be open to the public. The witness gets up, he reads, or she reads the witness statement into the record, and that ideally should be the end of the evidence in chief. So you don't have, if it's my case, and I'm calling this person for the plaintiff, I'm acting for the plaintiff, I'm calling this witness, I should not even have to stand up. can just sit there, wait for him or her to read the witness statement, and then I can sit down. And then my opponent should ideally start cross-examining. Unless issues arose after the filing of the witness statements or things that you need to amplify that's not in the witness statement, you say to the court, my lord, I need to address this, 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 and this with the judge for this reason, or with the witness for this reason, and then the court grants you the right. But the idea is that I don't stand there and lead questions now. So, sir, you are the plaintiff in this matter. Yes. So, how do you know the defendant? Well, you know the defendant. So that is eliminated. That's the whole idea. Remember, in the old dispensation, you would pitch up at court, and you would not have any idea who your opponent is going to call and what that witness is going to say. And you just had to deal with it. Now you are prepared to the extent that there's witness statements. Now, whether I am in agreement with witness statements or not is irrelevant. I do think it is open to abuse, but similarly, the previous dispensation was open to abuse. So I suppose one must look for the lesser of two evils, where, as I said, you're dealing with people who have to operate within rules. They'll always find a way around it, or try and operate with the road of least resistance. So the witness will come in, will take the stand. Please state your full names, take the oath, and then the judge will say, before he starts, read the admonition that's in the rule, Rule 92, Sub-Rule 4, I think it is, and then the witness would start reading his statement. And then ideally, if I'd done it properly, I should be able to sit down and not ask anything more, and then my colleague should be able to get up and start cross-examining. It's supposed to save time. It's supposed to take away the element of surprise. No, the judge doesn't say that. The judge says, you must now point out inaccuracies to me as you go along. So they'll read it and say, this is not correct, it's actually 2014. So the witness, as he reads through it, should point out where there's inaccuracies. So the judge is not asking him at the start to confirm. It's once you've read it in, I can accept that that's your evidence. So for when it's an English language issue, logistically it becomes difficult, you're quite right. So what would ideally happen, I suppose, you would disclose that to the judge, and the judge would make directions or issue directions that would assist the party. So you would consult, you'd have to get instructions from this person at some point. So what would happen is you would get a sworn translator to assist you, and you would then consult, obtain the instructions with the assistance of the sworn translator, and you would then draft your witness statement in English, or the translator will draft the witness statement in that language and then translate it for you, or that person or whomever assists the person. If it's a person who can write, they can write in their own language and have it translated. If it's a person who's totally illiterate, then you would have him tell his story, or her tell her story, and to an interpreter. Interpreter will convey that to the practitioner, who will draw up the witness statement, and that'll then it'll be stated in the statement. This statement is drawn up with the use of an interpreter, and the deponent or the witness is illiterate. So the judge will know that. And then when it's in court, that'll be, the admonishing would be different. It would say, it's going to be read to you. I understand that you can't read. It's going to be read to you. If what's read to you is wrong, you need to tell me. You see. So it'll be it's just an issue of practicalities. If you're able to testify in a court, it's possible that a witness statement can be filed on your behalf. If it's an illiterate, then they can't read, but they can speak. The thing is, of course it's a possibility. Depends on the circumstances of the matter, and then the judge will give directions to best suit the interests of justice. Not sometimes, often. So when I'm able to understand the language that the person's mother tongue, and I'm able to understand the interpreter, then I would object and say that's not what the witness said. So, but I mean, that's what more can you do? No, I mean, if it's an incorrect translation, that should appear from the record. That shouldn't be an issue. That hasn't changed by introduction of your preparation for trial. The procedure may have changed, but the substantive nature thereof hasn't changed by case management. For the simple, and why I say this is, you as a practitioner had in the past, even before witness statements, also had the duty to go through a fact-finding mission with your clients and the witnesses to see which witnesses are relevant, etc., etc. You would know in advance what the issues are on the pleadings, and you would have to file witness statements in anticipation of addressing those issues. Now, if, of course, you are a defendant, if a plaintiff, there's no excuse. You must have all those witnesses ready from the start because it's your case, you bear the onus. Where there's a reverse onus, same issue on the defendant. However, where the onus is on the plaintiff and the defendant filed simultaneously with the plaintiff, things may come up in the plaintiff's witness statement that you think that you need to address. And then you would, with leave from the court, be allowed to either amplify or file further witness statements. You can't be deprived of an opportunity to present a case. And then comes the issue of rebuttal and all of that, but that's trial procedures. We won't deal with that at the moment. So essentially, that hasn't changed. All now that you're required to do is to play your hand, where previously you weren't required to play your hand, so to speak. Well, in terms of the rules, it depends on whether further circumstances have arisen, whether there's a bona fide omission, whether new facts have come to light, or whether things may have come out in the trial or in the opponent's witness statements that give rise to the need to amplify the witness statement. But the court will grant that relief sparingly, simply because parties can't file a flimsy witness statement and then want to come and amplify an oral evidence, because then you're just defying the purpose of the rule, which is to actually just disclose what your witnesses are going to say in advance. Okay, thank you. I think that takes us exactly to 12:30, so we'll be back here at 2 o'clock, and we'll just finish witness statements and pre-trial procedures, and then hopefully, let's see, then we have 2 more slides, and then we're going to get to and costs. Okay, so we have and then we'll start with judicial case management. So we have some ground to cover this afternoon, but we'll do it. Okay, thank you. See you after lunch. Don't eat too much. You might be tired.